Brian Wilson, Mary Catherine Ham, Brian Neiman, today's newsmakers, and you, the Morning Majority. 105.9 FM, AM 630. WMAL.
7 on the Morning Majority. Brian Wilson is in the house, filling my regular slot, but Neiman is taking some time off, so is the lovely and talented Mary Catherine Ham. They'll be back soon. I think tomorrow both of them will be back. But we have, instead of Mary Catherine Ham, who is lovely and talented, we have the lovely and talented Major Garrett sitting in the guest chair.
The ugly and semi-talented Major Garrett.
Oh, not true, and we all know it. Hey, listen, we have on the phone our good friend and our legal analyst, Joe DiGenova, and there's a lot to talk about.
Very talented.
Yeah, and he's a very talented and handsome man as well.
Dapper.
Hey, listen, this is the first Monday in October. That means the Supremes are back.
Yep.
And it looks like this will be the term that they probably will have to deal one way or the other with Obamacare.
Yeah, this is going to be a big term. Major issues. This is the term that people have been waiting for. Obamacare, immigration laws, GPS tracking without warrants, a revisiting of the civil rights laws on admissions to universities. This is really going to be a big term, and this is going to be one of the historical terms for the Supreme Court.
Joe, is there any chance that on the question of the president's health care law, the Supreme Court could say those who have brought suit don't have standing and could render a very technical
they could do what the
judgment and not really get to the meat of the constitutional argument?
They could do what the Fourth Circuit did, although in a couple of the cases that are already up there, among the 26 states, most of those attorneys generals have citizens as part of the plaintiffs. Virginia did not. Virginia did not have any citizens as part of its lawsuit. The other 26 states do, as I understand it, have citizens as plaintiffs. So I think the standing issue is going to be not an issue in the Supreme Court.
Is it a sense in the legal community that the Supreme Court is eager to approach this case?
No, I think actually if they could figure out a way to put it off, they would, but I just don't think they're going to be able to. There is a conflict in the circuits about whether or not the law is constitutional, and that is a fundamental basis by which the Supreme Court reviews cases. So I think they're not going to be able to punt, even though they probably would not like to rule right in the middle of a presidential election.
Joe, as we look at the current makeup of the court, what often happens by court watchers is they look at their past rulings and where individual members came down, and they try to say, okay, well, based on that, we postulate that this is how they will vote in the future. I know sort of that is a little bit of that is folly, but it does give you some insight to their past thinking, and with the law, the past is so very important. What do you see as you look at that?
This is all about Anthony Kennedy. As usual, it boils down to 4 liberals, 4 staunch conservatives, and Kennedy, the swing vote. And people are doing all sorts of analysis about his past rulings and writings. My guess is he's leaning a little bit towards striking it down, but he's not a vote that you would think on Obamacare is a sure one for the administration. So similarly, the people who are proponents of Prop 8, the gay marriage ban in California, believe that Kennedy is worried about his legacy and may very well want to sustain the ruling in California that the ban is unconstitutional. So, it varies from issue to issue.
Joe, is it really for the court and the president's health care law interpreting the Commerce Clause and its reach and scope? Because I've listened to some legal commentators say it's a settled issue. The Commerce Clause has been interpreted by the court, and there's a history of precedent there that says you can engage in a law such as the health care law because the Commerce Clause has in the past been interpreted by the court somewhat broadly, and that that precedent alone argues in behalf of the court upholding the law.
Well, actually, that's a pretty weak argument, because although for about 30 or 40 years the Supreme Court did expand the power and interpretation of the Commerce Clause, it started about 15 years ago cutting it back and saying that the Commerce Clause had become too elastic a tool for the Congress, and it started declaring unconstitutional laws like the 1,000-foot gun ban in near schools. I mean, in a surprising series of cases, the court began to rule that the Commerce Clause was not as powerful as the court had historically said it was. So, if anything, the trend has been to cut back on the coverage of the Commerce Clause. It's just the opposite of what some of the proponents of Obamacare are saying.
All right, Joe, new topic. The killing of al-Awlaki, I think a good day for America personally. But, there is this sort of question about whether or not the president had the authority to basically order the assassination of an American citizen. I think he does. There is this question about why it's sort of ironic that the president thinks waterboarding is torture, but an assassination is okay. But given all that, does he have the authority to do what he did in your mind?
Well, I think he does, number one. And, of course, there is a legal memo that's been generated by the Office of Legal Counsel inside the Justice Department, which is the final arbiter on legal issues involving the power of the president, along with the White House counsel. That memo was widely reported over the weekend as having declared that the president does have the power to kill Americans overseas without process. It claims that the process of war is the only process that matters. Now, the administration is refusing to release this legal memo, even though at its beginning, this administration released all of the Bush administration legal memos from the same organization, the Office of Legal Counsel, on enhanced interrogation. So I think it's very important that the memo be released. I think ultimately it will either be released or be leaked. But, the bottom line is the folks on the left say that there is no war and there is no battlefield. The administration is saying finally now that there is a war and there is a battlefield, and the battlefield is not only America after 9/11, but also certain countries in the world, even countries with which we are not formally at war. So the president has taken what I would consider to be, this is a rich tableau of hypocrisy, has taken a very, very broad view, expansive view of presidential power and a presidential wartime power, and that is why some of his supporters are extremely upset with him.
Joe, it's a stickler point, but we have an authorization of use of military force, an AUMF, which covers much of the legality of the prosecution of this war on terror. As a matter of law, would it not be necessary, or should it be necessary, for Congress to do what it hasn't done by law, which is declare this an actual war? Would that make this a little bit more legally clear and defined?
I think probably not. The Supreme Court has now taken up a lot of these issues, although it has ruled that the resolution on the authorization of force is a sufficient power for the president to conduct the operations and do what he's doing. A formal declaration of war would certainly add a patina of respectability to any legal argument, but as of this point, it is not necessary. Because it is generally accepted by the Congress, which has the power to declare war, that it's already dealt with this issue. Congress, if it wants to say, you don't have the right to do this, can say so. But it chooses not to because it does support what the president is doing. And while there may be a few detractors in Congress who say the president should not be doing this, it is the position formally of the Congress that the president has the authority to conduct the war and to use all the associated powers, which include killing enemy combatants.
Joe DiGenova, always good to have you on the Morning Majority.